Welcome, everyone, to the Innocence Project Brooklyn Nets night. I want to thank the Brooklyn Nets for putting this on for us. Incredible commitment from them on so many levels. I want to introduce myself. I'm Jason Flom. I'm the founding board member of the Innocence Project. And my job is to introduce these incredible people, which I will do momentarily. But before I do that, I just want to give a little background. I got involved in the Innocence Project about 25 years ago, just because I saw a thing on TV. I was at my in-laws' house and I was bored, so imagine that. So I was flipping the channels and I saw a story of a case of a guy named David Keating who had been sentenced to death and was scheduled to be executed shortly when the Innocence Project, which was a nascent organization, had come along, discovered the DNA, and not only prevented his execution, but also had gotten him freed. And I thought that was one of the most profound things I'd ever heard. And so I basically marched into the Innocence Project, because back then you could, because there was nobody there. It was basically Barry and Peter in a little room with a briefcase and a phone and a dream. And I walked in and I said, I'll do whatever you guys want, whatever you'll let me do, I'll help you any way I can. So that's how I got to be the founding board member of the Innocence Project. And it's been an incredible journey. Hundreds of exonerations later, dozens of legislative changes that the Innocence Project has either backed or actually started and finished, that have led to countless numbers of wrongful convictions being prevented. So in every case there's a story, and an amazing story, of someone, an individual, some of whom are in the room. Like I said, Shabaka and Johnny are here, Shabaka Shakur, Johnny Hincapie. Felipe Rodriguez is here, who just got out last year, and Mark Denny's on his way. He'll be here shortly. So behind everyone is a story, and then from those stories come these legislative changes, which is the macro stuff, which is so awesome. So I want to just talk for a minute about the Innocence Network's partnership with the NBA, which is, I think, almost unprecedented. The NBA has stepped up in ways that I can't think of another major sports league having done ever, to bring awareness about this scourge of wrongful convictions in our country. And now the Nets have really stepped up as well, so big ups to them. And it's important to recognize the Brooklyn Conviction Review Unit, which is one of the most successful in the country. It's not because Brooklyn has more wrongful convictions than other places. It's because Brooklyn does a better job of sort of checking themselves, right? And going back and looking at cases and wanting to make sure that they got them right. And whereas a lot of other places in this country, unfortunately, protect those wrongful convictions even after they know they've been wrong. They just like to just sit on them, or it's reprehensible and it's ununderstandable. So in Brooklyn, they've exonerated 24 people so far. Under the leadership of Eric Gonzalez, he's carried on the work of Ken Thompson, the late great Ken Thompson, and they are continuing to be among the leaders in righting these wrongs. And so I'd actually like to give Eric a round of applause, and your staff, for the work that you've done. And so we also have the fearless leader of the Innocence Project here tonight, Maddie DeLone. We all take orders from him. From her. Where is she?
She's waiting for Mark.
Oh, she's waiting for Mark outside. So, Maddie, you're not here, but now everyone will tell you I shouted you out. And then lastly, I want to introduce our amazing panel. To my right, Nina Morrison is the leader of the legal team. Your official title is?
Senior Litigation Counsel.
That's what I thought, but I didn't want to get it wrong. So Nina her other title is Certified Badass, and I've seen what she does, and it would be bad to be on the wrong side of her. I've managed to avoid that fate thus far, and I'm going to try to continue to do that, so that's why I'm going to stop talking about her now. So Eric Gonzalez needs no introduction. He is the Brooklyn DA. He's a friend. He's a man I respect and admire. He's been on my podcast. I have a podcast called Wrongful Conviction, for those of you who don't know that already. I think it's great. And we're in our 8th season, and each week I interview someone who was wrongfully convicted and served decades in prison for a crime they didn't commit. And Eric has been on the show as well, which I thought was a great statement for a sitting DA. And last but certainly not least, and the tallest member of our group, easily, is Len Elmore, who's had just a remarkable life. I mean, as a prosecutor, both on and off the court, right? You went from the basketball court to the court, right?
A law school in between.
Yeah, and now a professor at Columbia Law School. Am I right?
At the School of Professional Studies.
School of
Sports
Professional
Management.
Studies, right. So Len, it's great to have you here as well. And as soon as Mark Denny walks in, Mark, I'm going to introduce him since he will be walking in any second, hopefully. Mark Denny was exonerated through the work of the Innocence Project and the Brooklyn DA Conviction Review Unit last year. Nina and I had lunch with him 72 hours after he got out, after 29 years, 10 months, and I think 4 days in prison for a crime he didn't commit. So Mark's one of just the most remarkable people I know, and he'll be here soon. So anyway, I'm going to turn it over to our esteemed panelists now, and thank you again to the Brooklyn Nets for hosting us.
Oh, my turn. First of all, let me say this is kind of a homecoming, having played for the Nets when they were in New Jersey and certainly worked for the Brooklyn District Attorney's Office. So, you know, it's kind of serendipity that I'm here, but I am very pleased that I've had the opportunity. Before we get started, I got my piece to say because as a professor at Columbia, a teacher dealing with social activism, criminal justice reform is something that is extraordinarily important to us, students as well as the faculty. And it's a constant refrain in our nation today. You know, unjust, draconian laws applied discriminatorily, as well as mistakes in the criminal justice process have led to mass incarceration over the last several decades, and it's a national disgrace. And yes, most recently, the First Step Act was passed, providing relief to the federal system and hope that the federal influence can abate the rush to jail citizens. But according to the United States Bureau of Justice Statistics, 87% of the prison inmates are in state systems. The U.S. leads all but one country in incarceration ratios. And at 593 persons incarcerated per 100,000, only El Salvador leads us. You know, among highly industrialized nations like Canada at 114 per 100,000, Germany at 75 per 100,000, and Japan at 41 per 100,000, our nation incarcerates at an alarming rate. Now, no doubt that there are violent and otherwise dangerous people who deserve to be extracted from a civil society. However, study after study has demonstrated there are far too many undeserving and even innocent people behind bars and on death row who shouldn't be there. A civilized society should not permit those injustices. That's why I'm excited to be here to witness a story of justice finally being done and an ongoing process that continues to examine our criminal justice system and process and advocate change to make the system fair and accountable for all citizens. So I'd like to say thank you to the NBA's Brooklyn Nets for allowing us to share this venue and use it as a platform to raise awareness of the efforts of the Brooklyn District Attorney's Conviction Review Unit and the Innocence Project. Thank you to the National Basketball Coaches Association for their partnership and their advocacy. So let us now witness and celebrate the story of Mark Denny, the Kings County District Attorney's Office, and their willingness to do justice than merely convict, and the Innocence Project, an organization designed to be advocates for those wrongfully accused, convicted, and incarcerated. So let us get started. DA Gonzalez, it's obviously apparent that your Conviction Review Unit was started for this type of case. Can you tell us how Mark Denny's investigation began?
Well, let me just also start off by saying thank you to the NBA, to the Brooklyn Nets, to the NBA Coaches Association, of course, to the Innocence Project, and to all of the folks who are here, including some exonerated individuals who came today to observe this. I want to acknowledge the chief of my Conviction Review Unit, Mark Hale. Mark, please say hello. And also Lisa Perlman, who worked on Mark Denny's case and did a tremendous job in helping to convince me that this case should be exonerated. And, you know, for us, this conviction review work starts. We get petitions in, sometimes from attorneys, sometimes from people who are incarcerated. We'll get it from, obviously, organizations and attorneys, the Innocence Project in this particular case. And there's a screening process by which we look for either actual innocence. But I think that what separates Brooklyn's Conviction Review Unit from other units is that while we look for actual innocence in doing our work, we're also looking for the denial of due process. And we're looking for errors, substantial errors that may have taken place during the course of the trial that we believe impacted the outcome. And because of those mistakes in the trial, the unfairness of the process, that it would be unfair and unjust to stand by those convictions. And if we see some evidence of that when the petition comes in, then we start to investigate those cases. And that's how, in fact, this case started, with really fierce advocacy from the Innocence Project on this case, because this case did not have any particular smoking guns that were obvious at first blush. But when you looked at the case more closely, you saw all of the problems that really caused me to say that this case needed to be an exoneration.
Now, the question, from this standpoint, how did this investigation begin, this particular one? What was the criteria for starting investigations of this kind?
Well, I'll let Nina sort of talk about how she did that part. From my perspective, by the time the case was being discussed with me, there was clear fault in the case in terms of the identification procedures that were being used, in terms of whether or not we were getting accurate testimony. There were so many issues involved in the case as it related to the lack of any other evidence that tied Mr. Denny to this crime. And so there were so many things that we unraveled, but the initial part of how we got involved in this, I think, was best said by Nina.
So yours, Nina.
All right, thank you. First, let me just give a thank you, as everyone has done, to the NBA Coaches Association and the Nets for making it possible. And, and there he is. Here's Mark. Make a grand entrance. How are you?
Nice to see you again.
All right. So we waited for you to come home for 10 years, and then we waited a few minutes more. It was like the empty chair was symbolic, but it's wonderful to have you here. So I was just thanking everybody who's helped make this event possible. And Mark and I used to talk about basketball on the phone, and in our visits sometimes when he would call, I was a high school point guard and not very good, and I used to dream that someday I'd be introduced at a major basketball arena by a basketball legend, and now my dream's coming true. But I'm actually a much better lawyer than I ever was a basketball player, so this is appropriate.
I think so was I, but that's
yeah. So the question was about how we started the investigation in your case. So Mark wrote to us, like many clients do, and he was on a long waiting list that we had. We currently have over 6,000 people from around the country who've written to us, and an entire dedicated staff devoted to reviewing those cases. We took Mark's case, and part of the problem with Mark's case from the beginning was that the evidence he was convicted on was so thin. It was essentially a one-witness identification. The witness herself, who had survived a brutal gang rape and assault at a local Burger King restaurant after hours, had her eyes covered for most of the assault, and initially said that there were 3 men who attacked her, which is what actually happened, but through the course of the investigation gave another statement that there might have been 4. And Mark was supposed to be this 4th person, and he was arrested essentially being in the wrong place at the wrong time, riding in a car with a family member and some others, and got picked up. And then the victim was shown his photo. She didn't pick him out. 2 days later, he was put into a live lineup, and she'd already seen his photograph and knew that that face was familiar, probably unconsciously from having seen him in the photo spread. And so when she saw him in a lineup, there's a signal that goes to her, whether the police intended it or not, saying, this is the guy you're seeing twice, he's somebody who looks familiar to you, and essentially a cue to pick him. Everybody knows now that that's not the way to do an identification procedure. But our problem was that the evidence that he was convicted on was so weak to begin with, and the jury heard it, and not being as informed as we are now about how misidentifications happen and how prevalent they are, they convicted him anyway. And in court, as you know, you usually need to go to a judge with something new, something you haven't presented before. You can't just say the jury got it wrong. So we did all the investigation we could. We had come up with some leads. We were looking for physical evidence. We couldn't find it after all these years. And we had a very good working relationship with Eric's office and the Conviction Review Unit. So my students and I wrote up, what was it, like a 30-page memo on the case and a summary, and we brought it to Mark and Lisa and their team and said, essentially, can we put this in your capable hands? We'll work with you, we'll help you, let's do this together, but we really need the power of law enforcement to get to the bottom of this. And we knew that if it was just us coming to court saying this is a wrongful conviction, probably nothing would happen for Mark. But if it was the prosecutors who were able to uncover some new evidence, we would win, and that was what happened.
Mark, we might as well get you involved right away. Obviously, being denied your freedom for so long, and how did you maintain faith that the system would ultimately work, if in fact you did?
Well, to be honest, I kind of lost faith along the way. But, my strength and my foundation really came from support from family members. I had support from family members because in prison, those things mean a lot. Even though I was in prison, I was in a dark, dark, dark place, still feeling like I belonged to someone on the outside and that I'm loved. That was like a big deal to me. So it was many different family members that played a part in that, some more so than others. And one of the ones that I always like to big up is Adetta James. That's like my favorite out of all of them. It's that kind of support that helped me part of the way, and the rest, like I said, is just up to faith, and it's just like an unknown instinct, an unknown drive that was in me to just survive and never give up.
And how much did you participate in, obviously, this investigation that led to your freedom?
Well, I didn't think my participation was much because what I had to say is pretty much the same thing I was saying all along. It wasn't me, I was innocent, I was not there. I really didn't know anything beyond that much. So I didn't really feel that my participation was much. What actually I was amazed by was that because it came to a point in my case where the physical evidence could no longer be discovered. So in my mind, it was like, my word wasn't being taken for nothing. The only best thing is the scientific aspect. Now that evidence is missing, so it's like I kind of went out at that point.
I will say, too, one thing that Mark did do as part of the process, which is very different about the conviction integrity investigations than what most people think of as the lawsuits or the court actions that free people, is that it was a cooperative reinvestigation between our offices. So after the DA's staff became more familiar with the case, they had a lot of questions for Mark about everything that had happened, and they needed to meet him and look him in the eye and ask him the hard questions. And rather than just say, no, you can't talk to my client or you can cross-examine him on the witness stand, we set up a time where I could go with the prosecutor and two detectives, and they conducted the interview. It wasn't me asking him the questions. I was just there in case Mark needed to ask me anything or something happened to go wrong. And that takes a lot of trust to have your client who might someday have to testify. So that's something that was built up through the work that we had done together on other cases, and frankly through my dealings with them over the previous year, where I understood that they were thinking about this case in an open-minded and positive way.
And I'll add to that is, our conviction review unit in Brooklyn is different. Much of the work that we do does not center around, DNA evidence or those types of exonerations. We're really looking at the hard question of did we get it right, and re-interviewing witnesses and re-investigating the cases. That is, much more difficult because there's not clear-cut evidence sometimes in this, and you have to kind of really, go through much more detailed, reanalysis of the case, and you kind of figure out where the investigation from the police side or the DA side, in this case, almost 30 years ago, went wrong. And we came to the conclusion that at a certain point, the police had come to the opinion that there were 4 people involved in this case, and they, the facts had to fit that theory, and that's how Mark became, a suspect in this brutal robbery rape case.
Well, you both have spoken of a collaboration between the two, and obviously Nina Innocence Project is nationwide. How typical, if at all, is that kind of collaboration?
So I wouldn't say it's typical. It happens. I mean, I have had the good fortune of working with several prosecutors' offices, not just in Brooklyn, some in Texas, some in Florida, that have really been a model for how conscientious law enforcement officials should go back and re-examine a case. I have had more cases, I would say, where I've had to go to court for years just to get a DNA test, not even to get my client out of prison, just to get the right to take physical evidence that could tell you with scientific certainty if my client did or did not do the crime, and if my client didn't do it, could potentially identify someone who actually did do the crime and might be a threat to other people, to go to court just to get permission to do the testing. I mean, we have donors who give us money to pay for DNA testing, so it costs the state nothing. And we will still have battles that can go on for years just to get DNA testing done. And that is really an attitude, I think, from the dark ages. There have been other cases where we get a DNA result or other new evidence, and then the prosecution will say, well, we still think your person is guilty because they must have just done it with that other person. Even if there's an eyewitness who's positive or a victim who's positive, there was just one perpetrator, they'll change the theory to say there were two to account for the physical evidence. So it's really all over the map. I think the fact that in Brooklyn, Ken Thompson and Eric Gonzalez and their staffs have shown that you can do this work well, and you can do it not just in one case, but in 24 cases, and get the support of the community, and it isn't something that's politically unpopular, it's something that's appropriately quite popular, has given other DAs, I wouldn't even call it the courage, but just kind of the certainty of knowing that going with what they know to be the right thing is politically something that's not going to hurt them either.
Well, when we talk about what went wrong in this case, you had mentioned that it was a bad ID, witness ID, and obviously Innocence Project deals with DNA and science. This is kind of a consult of science as well when you talk about witness identification. Can you explain what went on there and how it worked?
Well, years ago, and I've been a prosecutor for 24 years, we did not challenge witness identifications in the same way that we do now, and I think the social science is very clear. The high percentage, the overwhelming percentages of misidentifications, and sort of the unreliability of a single eyewitness identification under stress, under trauma, and in fact, often, I remember hearing many summations where it was like the person had such a clear and ample opportunity to focus in on the perpetrator. How could they get it wrong? And now we know that, in fact, they do get it wrong all the time and often. And so it's changed our practice as current prosecutors. One of the things about this conviction review unit that I think is so important to what we're doing, not only are we giving people back their good name and getting people out of prison, but I'm hoping that the work that comes out of this and the work that we've learned under identifications and false confessions and other areas of error in our courtroom will make sure that that does not happen again. And so it's a big part of the conviction review unit, not only to get people out of jail and to clear their names, but to make sure that we're training our assistants and we're training our lawyers about the errors that have happened. Because so many things that were commonplace just 20 years ago, today we realize the folly of it. And eyewitness identifications, for example, is one of the areas where we relied on cases. And I know that many prosecutors have tried a case, and if you ask them, do you know if the accused, the defendant, is guilty, they would say, I don't know. I know that the witness has ID'd them. And it was not that sense of moral certainty in going forward with cases, which I think is necessary for us in Brooklyn. It made us, really rethink whether or not a case without any other evidence, solely based on a fleeting identification, should even proceed to trial. And so that's how this work is changing the practice of law and criminal justice issues in general.
And Mark, this process has exonerated you. You've gotten your good name back. Tell us, what are you doing now? What's your future plan?
Well, when I came out, I made mention of one of my future ambitions was to own my own business, specifically a barbershop. That's still in the makings. As of right now, I'm still adjusting to society. I'm still adjusting to my family. I'm still adjusting to, all the new people I'm coming into contact with. I just, Nina Morrison just hooked me up with a job. I just got a job working at a hotel. So I'm meeting a whole bunch of new people. I'm getting, familiar with just being part of a team, teamwork and things of that nature.
Actually, I should say, it wasn't me who got him the job. We have a wonderful partnership with the Hotel Trades Council that's gotten jobs for several of our clients who's come out of prison. And so he now has a good union job with benefits, and
yes,
that's pretty great.
So it's a great feeling, to have my name cleared, to be, in my mind, to be appreciated by everyone all over again, because even people that didn't even know me, in my mind, I stuck out as a sore thumb to everyone. So, my mind is no longer in that state no more, and I'm just having fun with it. I'm working, I'm trying to get my life together. There's a lot of things that I'm doing that I'm not really privy to talk about right now, but, my exoneration process and my adjustment to society, everything is just going great.
Can we talk about the
I really
half
have
marathon?
no complaints. Excuse me?
Can I tell you about the half marathon?
I'm actually training for the half marathon, yes.
So the law student who worked on Mark's case with me, Sarah Judy, and he are running in their first Brooklyn half marathon in March. And if you want to sponsor them, you can go to our page.
I've been losing a lot of weight,
And now
too.
I've shamed you into it. You're going to have to keep training. 'Cause
And Mark, when we met the day you were going to court and, I told you that we were going to exonerate your case, I apologized to you as the Brooklyn DA for what had happened to you. And, here in public, I think it's important that I do that again, because what happened to you
Thank you very much.
should never happen to anyone. And I think about this often because I grew up, we're about the same age. I grew up in East New York, and I think about, my friends, my family, people that I know, that you could get caught up and be in the wrong place at the wrong time, and your life can change forever, and that our system needs to be better. There's no higher obligation than prosecutors have to make sure that we get this thing right. And we got it wrong 30 years ago. As the DA of Brooklyn, then, I apologize for what you went through, and I am glad that we were able at least to say that publicly, that you were not guilty of this crime.
I appreciate hearing that. I appreciate hearing that very much.
That was well said. And
And I will say so many of our clients never get that. I mean, we have a lot of clients that have been legally exonerated, meaning their convictions were thrown out, the charges were dismissed, and some prosecutors, some police officials will still say, well, we just don't know what happened, or we still think he's guilty, but we can't prove it. And that recognition, not just that they're free, but that the system wronged you and that you're innocent, is something that's so important and not enough of our clients get. So I appreciate very much you saying what you did.
And the attorneys at the Innocence Project obviously work on so many cases, and professional abilities aside, with the injustices that you see, how do you guys avoid having to take such an emotional toll? Because I know it'd be really hard.
I don't know. I've done this for 17 years. I think you have to take some breaks and you have to have some perspective. And, I have a weekend basketball game. You're welcome to come join us anytime. Mark came with me once. That was fun. And, you try to take care of yourself. But I think I'm very lucky. I mean, the criminal justice system doesn't have a lot of moments where anything good happens. Like, even when somebody gets convicted of a crime that they did commit, it's just sad for everybody. There was a crime, there were victims, there were witnesses, there's a defendant, there's their family, they might go to jail, or, it's just a sad day. There's no joy in that courtroom, even when the system gets it right. And I've been lucky enough, Mark is my 22nd or 23rd exoneree to, be part of a day where people are in that courtroom and they're smiling and they're happy. It obviously comes with a lot of pain behind it. It's bittersweet, and we know there's a lot of pain in the rearview mirror, and for our clients, a lot of adjustment when they get out. But where the system actually does what it should, even if it's 30 years late, and acknowledges a wrong that was done, that is a moment we can all be proud of. So one of those will get me through the year, and then I just hope to have another before too long.
And speaking of the system, Eric, what changes do you make, if any, after cases like Mark's and others with regard to how you prosecute cases going forward?
Well, it's forward-looking, and as we've exonerated now 24, people, there's a lot of things that play into this. It's racial and social justice. 23 of the 24 people have been, people of color. And so we see the impact of, law enforcement practices on communities of color. We are very mindful of, the issue of identifications. Years ago, I don't think that, prosecutors believed in the concept of false confessions, right? There were confessions, obviously, if someone had been, beaten up at the precinct, the detective was beating them up, maybe, but just the thought that someone would confess to a crime that they didn't commit for the various reasons now that we know that they did. And so we look at these cases, more comprehensively than simply we have an identification or we have a confession. We are looking to see whether or not the pieces of the investigation actually make sense. We were too good and first of all, we're coming from Brooklyn, right? So in Brooklyn, I grew up in East New York in the 90s. My neighborhood had 126 people killed in the 90s, and Brooklyn had over 800 people were murdered in Brooklyn. And so jurors and the courthouses and attorneys and DAs were all overwhelmed, and I think jurors wanted to hold people accountable. And so there were a lot of errors made, there was a lot of shortcuts that were done because the volume of cases. It's not an excuse, but it's definitely understanding the time period from which we were coming out of. Today, one of the things, for example, in my office is we often will not proceed with an identification case unless there's other evidence that supports that, and even if it's a high-profile case. And also, the thought that, in order to do this work, that the person has to be an angel, that the person who's been convicted of this, whatever crime you're looking at, that they didn't commit other crimes in their life. I think too often prosecutors, they stop. They're not as inquisitive. They say, well, look at this person's, record. They've done this. They've done other crimes before. The fact that we're looking at these cases now and really saying, do we believe by a moral certainty that this person is responsible? Does the evidence lay it out? And not just be so good at our jobs as, trying to figure out ways to explain major holes and deficiency in cases. That was the thing. When you look at a lot of these cases, we had a lot of clever lawyers who made a lot of clever arguments to jurors who were looking to hold people accountable for, these terrible crimes. And we have to step back, and we have to make sure that the prosecutors of today really understand it's about getting it right. It's not about getting that conviction. There's no clearer way for me to do that than to say, in some cases, the holes in the case, really suggest innocence, and so we shouldn't even proceed.
Well, before, and I think it's probably a good time to kind of turn it over for questions from the audience, but before we do that, I'd just like to ask our panel, is there anything left unsaid?
I think we've solved all the problems with wrongful conviction, don't you? No, this has been such a great forum, and I'm really thankful to everybody who's here. I did want to say one other thing that Brooklyn has really been a leader on in New York in particular, which is that your office, starting even before you got there, but solidifying when you got there, has been very committed to early and open discovery, meaning beyond what New York state law requires, their prosecutors are told that they're expected to give the lawyers for the defendants access to police reports and witness statements much earlier than state law requires, because New York state law is one of the most restrictive in the country in terms of how you know the case against you. And this year, in large part thanks to the leadership you've shown, to exoneration cases where we've seen defendants from the 80s and 90s and even more recently who didn't get access to very powerful evidence of their innocence because it was buried in a law enforcement file, Governor Cuomo put in his budget a plan to fix New York's discovery law that we're very supportive of. And so these cases really are helping drive the way not just we see convictions behind us, but the way that prosecutors and police will be doing their jobs going forward, which is going to make the system better.
And I think that's a critical component. We have to make sure that defense attorneys have the information they need to assess cases and do their jobs. And so for a long time, the Brooklyn DA's office has been very, a big proponent of open file discovery. There's this new discovery law that I think will be signed in this session. But for my office, we're looking to do even more than the law is going to require. We're going to be, we're in the process right now of testing out electronic discovery and early discovery, including giving discovery at arraignments. I think we're the only district attorney's office that gives arraignments discovery at the arraignment. So even before anyone pleads guilty to a crime, lawyers would have some information to counsel their clients. And I think that is something that is so important in fairness that I hope that this work that the Conviction Review Unit is doing helps promote that, because so many of the errors were because people didn't have the records and didn't have the information. And we're going to make sure that Giglio and Brady and those kind of things, those legal obligations of prosecutors are actually turned over. Doing it early and having a bait stamp is going to make sure that it actually happens. So I want to thank Nina for mentioning that, because I do think in order to prevent wrongful convictions, we really have to make sure that prosecutors are held to fire on this issue of discovery. It can't be a week before trial or 2 days before trial or during jury selection.
Mark?
What I could say to that is that, from how I see things, it all boils down to all these, officials we have in positions that the common people depend on them to actually, function truthfully and honestly in. At the end of the day, when things go wrong, it's because somebody is not playing by the rules. Because I look at the rules, and the rules is good. The rules is good, the rules is just. But we need people that are just, people that are filled with integrity, people that can be trusted to do the right thing, but nobody is watching them. As long as everybody play by the rules, even when we make mistakes, it'll be honest mistakes, and therefore it'll be honest correction. So the bottom line, I think, is that everybody has to play by the rules.
Well, those are words to live by. At this point in time, let's give a round of applause for our panel, for sure. We do have a question that's for you, Mr. DA.
So the question said, your Conviction Review Unit has been called a national model. What are the aspects of the way the office is run that you think has made it so successful? And it's a great question, because I think it's an important question in how we do this work. It's a dedicated unit. The unit is not accountable to anyone but myself and the chief assistant, so that the work that they do gets filtered directly to me. There's not going to be any pressure on the unit by other prosecutors not to push forward on these exonerations. It's a fully staffed unit. The unit costs a lot of money. We're lucky in Brooklyn that we have a budget that allows us to staff it, but they're full-time investigators and paralegals. And it's a unit that is trying to make a difference, not just in Brooklyn, but nationwide, because we have consulted with, at least 10 other major DA's offices across the country, helping them start their units. Because the one thing I will say is that when we do this work, it does take a lot of courage, because there are victims and families and advocates who may not like what we're saying to them. Not only has the person who's been wrongfully convicted suffered, but we also let down victims and families and communities who we told we've solved this crime, we held the person accountable, and then we have to go back years later and say, no, actually we didn't. And I think there's one final piece to the conviction review unit, besides having very dedicated prosecutors who want to do this work, is in Brooklyn we have an outside independent review panel. Those are volunteer lawyers who we trust, and we give them the results of our investigation. They also may have questions, they may also direct parts of the investigation, and they make a recommendation to me as well. So we have our own internal team, the Conviction Review Unit, that's making a recommendation, and then we have an independent review panel. That means that we're showing transparency with this outside group of lawyers, letting them see what we see, and they'll make a recommendation, and then we'll make the decision. I'll make the decision. But I think those are part of the factors that make this, really a gold standard for how you do this work.
All right, this next question is from Mark. It's actually a two-part question. The first is, are you a basketball fan?
Excuse me?
Are you a basketball fan? It's not from me. This is a question. Legit.
Yes, I am.
All right, who do you root for?
Chicago.
Uh-oh. Never ask to follow up if you don't know the
Enemy
It's
answer.
an age thing. Our generation was all, the MJ era.
I'm not a die-hard basketball fan where I have a certain team in particular, but I always liked the Jordan, and before I got locked up and went to prison, that was like my favorite basketball idol. I kind of lost the spirit along the way, but, I still root for the sport. Even though I'm in Brooklyn, I'm in the Brooklyn Nets home, that just came out instinctively. Had I thought about it, I would have said.
Well, for one night, you can be a Nets fan, right? The second part of the question is, what do you think about the Innocence Project's partnership with the Nets and the NBA?
I think that that's a great partnership because, basketball players have a lot of influence on people in the world. People listen to them, especially younger generation. They love sports and they really listen to them. So by them linking up with the Innocence Project and projecting that message, I think it'll get to a more wider audience. I think it's a good, powerful collaboration.
Great. All right, Nina, kind of popular. I got a bunch of questions here for you. The first one is, how many of the Innocence Project's exonerations are the result of collaborations like this with a conviction review unit? And the second part is, are prosecutors typically supportive when you present evidence of someone's innocence?
I don't know the exact number, but it's a growing number that are the work of collaborations with the conviction and review unit. So in my cases of the 3 in the last year that resulted in exonerations, 2 of those were collaborations with the conviction review unit, one in Brooklyn and one in Texas, and neither of those involved DNA evidence, but in both of those cases, the prosecutors came to court and not only said the person should be exonerated, but said that the defendant was actually innocent and apologized to them for what the system had done. So the good word is spreading. It's getting out more. And what was the second part of the question?
The second part of the question was, are prosecutors typically supportive when you present evidence?
Yeah, as I said earlier, they're all over the map, literally and figuratively. And I have found some really good people in what I guess would be unexpected places. So I don't think you can assume, based on the geography or where they are or who the person is, how they're going to react. And I've been heartened by the fact that prosecutors are people, and no prosecutor goes into that work wanting to convict an innocent person or keep an innocent person in prison. And sometimes you just have to meet them where they are and do your best. And I really pride myself on trying to, approach it with that spirit that everybody wants to get the right results. Some of them, I think, come from offices where the culture is just to instinctively oppose anything that a person in prison says or tries to do. Some of them are protective of the people who came before them. Maybe the DA who did the trial is someone who mentored them or was a friend of theirs, or they knew and don't think that person would ever get it wrong. But we are making some progress.
And the second question, actually, I'll let you read it because you might recognize the handwriting.
Okay, this is from an 11-year-old with handwriting that I recognize because I gave birth to her. She's here, my daughter Anya, who's here today. Her handwriting is as challenging as mine, so I'm going to do my best to read it. Nina, when did you get into the case and how did you solve it? And she put in an AKA parentheses, what did you use?
Secrets. Okay.
So she's crafty. So I actually, interestingly, got into, when did we accept your case? 2009? 2008? 2008. So you were 1 year old. Mark wrote us a letter, and our staff reviewed it, and we decided to take his case. And so I was Mark's lawyer for more than almost 10 years, exactly. It's a long time. And I want to thank also our law students, because there was a period where after we couldn't find any DNA, we usually will close a case, or not usually, but sometimes, unless we can find a reason to keep it open. And the students who had visited Mark and talked to him on the phone so regularly as I had kept saying, you can't close it, he's obviously innocent. So we found a workaround. And then how we solved it was really working with the DA's office to re-interview the people who were involved in the case, who gave statements admitting what they had done and confirming that Mark was not there, which was something they didn't have to do. One of them had actually never been convicted of the crime, so it was at some considerable expense to himself that he did that. And working with the prosecutors to get behind the science of misidentification. And I would also like to give a shout out to a wonderful group that we haven't mentioned yet called Healing Justice, which works with the survivors of crime as well as the wrongly convicted to help make the system better for people who have survived the original crime, as well as people like Mark who have been victims of the justice system's errors. And they worked closely with the Conviction Review Unit in this case to help figure out how to talk to the rape survivor here and to treat her during the process with the respect and the dignity that she deserved, so that ultimately, when Mark was declared innocent and exonerated, she understood a couple of things. One, first and foremost, this was not her fault. She was as much a victim of the system's errors as Mark was, and she did nothing wrong. She did her best under the most difficult circumstances anyone can imagine, and that Mark bears her no ill will, we bear her no ill will, and certainly the DA's office doesn't. And number two, she understood that her memory had been inadvertently contaminated by procedures that the police had used. You know, not anything that she did to get it wrong. She desperately wanted to get each and every one of her attackers' identities right. And I really give a shout out to Healing Justice for filling a role in our community that hadn't been filled before they started their work.
This next question, I'm not sure if it's relevant to a case at hand, but somebody's asked the question, how do we protect and secure the right of a defendant appearing before a grand jury? And how do we resolve the issue of secret indictments? Sounds like another case, maybe in Washington.
I'm just an appellate lawyer, so I'm going to let Eric take that one.
You don't have to answer it. All right. DA Gonzalez, this is for you. How does the Conviction Review Unit change the culture of a prosecutor's office?
That's a great question. As I've only been the elected district attorney for a year, I was chief assistant to the prior district attorney, Ken Thompson, who started this unit. For us, when we took over the office in terms of what we were hoping to accomplish, we were hoping to accomplish a sea change in the way prosecutors viewed their jobs. And it really stemmed from the sense that we were trying to end mass incarceration, that the use of jail and prison should really be for the most dangerous offenders. And looking at the work of conviction review, what it did was it made the rest of the office understand that there's a real great satisfaction in making sure that we get it right and that it's not just about convictions. And I'll tell you a short thing that happened the last few days. I've been going around to the different bureaus in my office and just congratulating them on the work that the office has done in terms of reducing the number of people that we send to Rikers Island, the different measures of progress that I feel that we've made in Brooklyn to make us a fairer office. And I've asked them, do you have cases in your inventory where you think the person may be innocent? And there's a few hands that go up. And I say to them, do you have cases where you feel that the witnesses are not telling you the truth? And a lot of hands go up. And so the work of the prosecutor, and I said to them, there's value in us getting those cases right to make sure that those don't turn into wrongful convictions, that we're doing this job about justice, and that we are infusing and using the conviction review's work to infuse that thought within our prosecutors. They get as much satisfaction from making sure that cases that should not be prosecuted end, and no one is convicted or sent to jail, and that we are measuring that we're giving them as much credit and even more credit for doing that work than just simply getting a conviction. That it's more meaningful for the people of Brooklyn that we are not convicting people when we think witnesses aren't telling us the truth or we think we may get it wrong, that it's much more important for community trust of our justice system that prosecutors are deemed to be fair. And I think that really comes out of the work that Conviction Review Unit is doing, because when Conviction Review started, a lot of people thought that they would be viewed sort of as an IAB, an outside force within the office, overseeing other prosecutors' work. I think what in fact happened, at least in my office, is that Conviction Review is being seen as a place where people who care about getting it right are working, and I think that will filter down to the rest of the troops. And not only here in Brooklyn, but I do 100% say when our Conviction Review Unit started, there was only maybe 2 or 3 places in the country who had this, and now it's spread much more.
Yeah, and I just want to say that the fact that you're having those conversations internally with the bureaus in your office is really extraordinary. I mean, we're seeing more of it, but I grew up in New York for a big chunk of my life and my young adulthood, and the idea that in the 90s, a district attorney would go congratulating his staff for not sending people to Rikers Island was something none of us really thought was possible. And that it's not just the things the district attorneys say when they're running for office, although that matters too, running on a platform as you did to reduce mass incarceration and make incarceration not the first option, but the option of last resort in a prosecution. It really has to translate to what messages do they get on the job every day? Are they rewarded for things like dismissing a case because the evidence isn't there, or the prosecutor has a suspicion or some real evidence that a witness isn't telling the truth? Is that going to be recognized as much as winning a big trial? And obviously winning big trials is important, it's part of their job, but to make sure there's some balance there in what gets recognized. And I think you and some of your peers are doing that, and it's really wonderful.
How many years has a Conviction Review Unit been in place?
Well, as currently constituted as the Conviction Review Unit, it started in January of 14.
Okay, the next question, and maybe adjust the years. What advice would you give to a person, and I think, Nina, maybe you can answer this. What advice would you give to a person who's had their case before the Conviction Review Unit, and it says over 10 years, but if it hasn't been in place that long, maybe there's some other body, authoritative body that's been in front of. But someone who's had a case that long, what advice would you give? And then DA Gonzalez,
it's very hard
yours.
to advise in the abstract because every case is different. I think if the person has a lawyer, that always helps. There's more of an ability to contact. A squeaky wheel can get the grease, and lawyers can often be good at making sure to stay on top of. Poor Lisa and Mark, they gave me their cell phones way too early in the process, and were getting calls from me at night and on the weekends and all these times. They didn't need to be here for me to ask if they were doing the thing they told me yesterday that they were going to do. But, you know, I'm unusually persistent, but I think it does help to have representation. And if you can't afford representation, to write to us, to write to Legal Aid Society, to write to the Brooklyn Defender's Office, wherever your case is, and see, or the Bar Association, see if you can get some help. You know, I think to some extent, I hate to tell everybody to trust the process because my experience may not be typical, but I think if you're a lawyer dealing with these units, it does require some trust, you know, balanced with your own healthy protective instinct towards your client to make it work. Because if you're not going to put trust in the process, you might as well just go to court. So,
2 more questions, and DA Gonzalez, this is for you, and this is interesting. Is there any proposed action to create a unit that can review a claim of innocence prior to the conviction in order to save the wrongfully convicted from doing decades in prison?
I mean, it's an interesting concept, and what you're asking is whether or not, you know, we can sort of take a closer look at the work product of assistant DAs that are going to court and trying cases. And I think the answer is with better training, with more supervision, and with more responsibility, that we could prevent wrongful convictions. Because as I was trying to say earlier, and I'm not sure that I was clear, often I've heard prosecutors say this, we'll let the jury decide. And I think it was an abdication of responsibility. I don't think that if a prosecutor is unsure of the defendant's guilt, that they should abdicate their responsibility and say, we're going to let a lay jury resolve this case. There should be a sense of certainty in the evidence, that you know and you believe that you're doing the right thing. If you're uncertain of whether or not the person is actually guilty, to let a jury decide it, I don't believe is appropriate. And it's one of the things that we've been now talking to our lawyers, and that is part of the training that I think needs to happen on the front end.
That's great. And to close, Mark, you get the last word. How did you feel when you were told by Nina that the district attorney was calling for your exoneration?
I was blank for a minute. I was like blank, you know, just blank. Just nothing wasn't going on inside of my head. And then when my thoughts started coming back, I was just overwhelmed by all the doubts and the pessimism. Because at that point, you know, the pessimism was so overwhelming. It was like the news that I was exonerated. I was like the refreshment that I need, the charge that I really need to just feel alive again. I can't really explain it. Words can't really explain it. It was just like an explosion inside of me for the better. I was just anxious now. You know?
Well, again, a wonderful panel. Thank you very much. Thank you all for joining us.
thank you.
And I think we're done.
Can I ask a question? I'm sorry, I didn't write it down, but it's for Eric Gonzalez. Do you believe that John Duca is innocent? And if you do, what is he still doing in jail?
Well, obviously, as you know, that case is pending before the Court of Appeals, and so our conviction review unit looked at that case, did not find actual innocence in the case. So I can't speak more to it. It's a pending court case. It's before the Court of Appeals, and I think, you know, in the short order we'll get a response back from them. You know, it's a tortured history in that case, but the evidence of guilt was laid out before a jury. There's been, as you know, and there's been recantations. You know, one of the unfortunate pieces of the job, and one of the toughest parts of being the district attorney and making these decisions, is you have to look at these recantations and say, are they legitimate recantations, or are they the product of coercion or threats or inducements? And so this is a case where we felt that, you know, there wasn't enough to vacate as part of the conviction review unit, went through the 440 procedure, and now it's pending before the Court of Appeal. But I'm hoping we get a decision soon.
Excuse me, I don't know
Roberts. I spent 17 years wrongfully convicted. I was exonerated in 2014 by DNA evidence. I'm here on behalf of the Innocent Project. And one of my question is, what a statistic as high as, at least the criminal justice system is based on guilty pleas. The statistic is 94, maybe 95% of plea agreements. Well, it's such a high statistic, we know that there's a process that's going place. Now, my question is this. Prosecutorial conduct and misconduct has been an issue because of the lack of accountability, the lack of oversight. What steps are being taken in today's time, knowing these facts, to address that matter, those issues?
Well, we're kind of moving away from what we're doing here, but I think there's a couple of things that to be said. One of the things that I'm a big and staunch supporter of open file and early discovery is so that people don't take pleas in the dark, and that there's enough information that a lawyer can actually counsel a person to plea, so that people aren't pleading guilty just to get cases over with, or they don't feel that they don't know what the evidence is against them, and they're facing the unknown at trial. So I think that is a big part of it. I also think that in terms of guilty pleas, when we look, and I think we may be unique in this as well, when our conviction review unit looks at cases, we also look at cases where people have pled guilty. We have vacated guilty pleas because we realize in some of those cases the pleas were a product of, I'll call it coercion because of the way the process worked.
Yeah, Rodney, thank you for your question. Rodney has been a really incredible advocate across the country for looking at the fact that innocent people don't just get convicted at trial, they are often, and I will say coerced by the systemic forces in place to take pleas to crimes they didn't commit. And we know Rodney is innocent because of the DNA evidence, and that's happened to many of our other clients. For people who are more interested in that issue, there's a great report that the National Association of Criminal Defense Lawyers put out last year called The Trial Penalty, which talks about the legal structures that are in place. Somebody, no matter how much they want to go to trial and clear their name and avoid having a conviction on their record, if you're being offered, 2 years in prison if you plead guilty to a crime, and maybe you have a child who's 5 years old, but if you go to trial on the same charges and lose, you could get 10 to 20 years and not be around for any of the rest of your child's growing up years. Many of us who are innocent would feel a lot of pressure to take that plea, and that happens way too often. And so a lot of the more progressive prosecutors' offices are looking at ways to reduce the unfair advantage the law allows them to have to pressure people into pleading guilty. It's a really hard problem to solve in some ways because our courts, we prosecute so many cases, and our courts are just not set up to do that many trials. And so if we're able to reduce the volume of cases and not bring so many in the door in the first place, especially for less serious crimes, we'll have more resources to make sure that people who really deserve and need their day in court to clear their name or put on a defense get that day.
You know how the band comes back on the stage for an encore? That was it. We're done. Thank you.
Thank you, everyone.